Jonathan Pollard, competition lawyer. I'm going to talk today about sale of a business non-compete agreements and more generally, why you always need litigation counsel involved with business sale transactions. So let me just jump right into the mix. Every week or so, my office receives a number of inquiries from folks who have sold their businesses, are subject to a non-compete agreement, and are now contemplating their options for possibly getting back in to the relevant industry. So, as most people know, anytime somebody sells a business in America, they sign on to an incredibly broad, aggressive non-compete agreement. I frequently see business sale non-compete agreements as part of the APA that are for 7 years and worldwide, or 5 years and worldwide. And often what happens in these situations is the folks who own the business have been doing it for 15, 20 years. They've reached a point where they feel it's no longer worth the headache, the day-to-day grind, the 70 or 80 hours a week, the headache of managing the enterprise, and they think to themselves, we're gonna sell the business and take a couple years off and then go do something else. And that's their game plan. And often in that scenario, although it might sound insane, I have seen it dozens of times where folks sold the business for 10, 15, 20 million dollars, sat out for 2 years, and now they're going stir crazy and are basically saying, well, what else would I go do? I want to get back in, I miss it. I actually realized that I didn't want to sell it. I just needed to take a break and sort of decompress and relax for a year or two. And now I want to get back in and I feel like I can do it even better than I did it before. I have seen that scenario dozens of times. I've also seen the common scenario where folks sell their business, to the acquiring company and then go work for the acquiring company. They go work for the buyer, sort of running a particular division within the company, and that corporate marriage often goes south in a hurry and simply does not work out. You have the seller who was used to running the business, used to calling the shots, had their own culture, had their own way of doing business, had their own way of treating their employees, their family, their staff, and they merge into this bigger enterprise, and the marriage is simply a disaster and a poor fit. And now they're scrambling and they're saying, okay, we're miserable here. We don't want to work as part of this bigger enterprise, but we signed an aggressive non-compete agreement as part of the APA. So what are our options and how can we possibly get back in? The problem here is that I invariably see these types of situations, these types of disputes on the back end. I never see them on the front end. Why? Why do I never see these types of situations at the deal or transaction stage? I'll tell you why. It's because everybody in the business world lingers under this delusion that deal counsel or transactional counsel, folks who write the contract, that's the only person you need in the context of a business sale transaction or APA, that you're best served somehow by hiring a lawyer or a law firm that writes up lots of asset purchase agreements. And so look, I get it, right? If we're talking about some kind of crazy mezzanine finance, $2 billion transaction, yes, you obviously need specialists who do transaction work, they do deal work, and they do exactly X. That's what you need. But in many transactions, and particularly in sale of a business transactions, you need litigation counsel. And you particularly need litigation counsel with an eye toward your biggest possible concerns. And what are your biggest possible concerns going to be here? Well, your biggest possible concerns, the way I see it, and from having seen hundreds of these types of situations, your biggest possible concerns are either one of two things. They're either one, default and lack of payment by the buyer, okay? So it's a situation where, the buyer agrees to acquire the company for $15 million. They pay $10 million up front, and then they pay $5 million over a sort of 5-year restricted term. But they breach the repayment obligations, and then there's something squirrely in the APA saying that the non-compete applies no matter whether or not they breach. That's shenanigans, okay? Who would let that provision be contained in the operative APA? Well, apparently, lots of transactional deal counsel lawyers who assist people with selling their respective businesses. The bottom line is that your two biggest concerns here from a transactional standpoint, in my opinion, from my perspective, are default and the non-compete restrictions. Because one, you want to get your money. If you sold a business for 10 million or 15 million or 20 million or whatever it is, you want to ensure that all of that money is paid. You want to ensure that there are teeth that attach in the event of any sort of default, okay? And so you need to protect yourself in terms of what your remedies are. There are many asset purchase agreements that are written in such a way that, first of all, there's an extensive notice and cure provision and period so that folks can default and basically waste 6 months on sort of back and forth notice and cure, and then you have to go mediate it and it's not binding, and then if you can't resolve it in mediation, then you have to go to arbitration. And this is absolutely shenanigans, and I'm not sure why people agree to these sorts of things. I certainly would not. In fact, I would rather take a discount. I would take a substantial discount on the purchase price in order to build in more favorable terms and protections. Because perhaps it's a situation where, the business is sold for $16 million. Well, guess what? I would rather take $1 million haircut and sell it for $15 million and get some more favorable terms with respect to choice of law, jurisdiction, forum, whether it's arbitration or litigation, non-compete restriction, remedies in terms of a breach or a default. These are all pertinent considerations that your deal or transactional counsel should be looking at, especially in the sale of a business context. The problem is that many lawyers who broker these types of transactions or serve as deal counsel in these types of transactions, they are not litigation attorneys, and they are certainly not specialized litigation attorneys who have litigated sale of a business non-compete cases and who are looking out for that as one of the most significant issues. They're not attorneys who have litigated the deal going south, who have litigated the sort of corporate marriage falls apart and there's allegations flying around about default on one side and then breach of fiduciary on the other side, non-compete, fraud in the inducement. You need somebody in the mix who has litigated those types of cases, and you need them to basically issue spot. Okay? So if it's a very complicated transaction and the stakes are high and there's many millions of dollars at issue, it is penny wise and pound foolish not to bring in additional deal counsel, specifically litigation counsel, to vet the deal with an eye toward what happens when things go south. Because things invariably go south in these types of transactions, and you can build in protections on the front end if you get the right advice, so you do not find yourself in a situation where you sold the business for $15 million, they've paid 10, they've defaulted on 5, but the way the transaction was written, you are still frozen out of the market and subject to a non-compete agreement. Jonathan Pollard, competition lawyer, Fort Lauderdale, Florida. Thanks for watching. Have a great day.